Hello, everyone, and thank you for joining us today. I'm super excited to introduce our speakers. First, I want to quickly introduce myself. My name is Nicole Bethurum, and I am a Senior Case Manager and Vice President of Marketing at ARC. ARC is a full-service dispute resolution company. We have been in business since 1987, making us one of the first in the industry. We are currently conducting most hearings via Zoom, with very few going forward in person. But I just did want to mention, for anyone interested, ARC does trainings for staff and attorneys prior to scheduling, so if you're not comfortable on Zoom yet. And I would like to note that all three of our speakers are full-time neutrals with ARC. Our first speaker is Jeffrey Kravitz, who was a successful entertainment litigator for more than 20 years. Mr. Kravitz is a former partner at the prestigious firm of Fox Rothschild. He has been named by the Daily Journal as a top 10 entertainment litigator, and Jeff specializes in mediating and arbitrating entertainment, business contract, IP, and insurance cases. Our second speaker today is Peter J. Marks, who has served as a mediator for over 30 years. Mr. Marks brings extensive experience and ease to the negotiation table. And one client of his was quoted, "Everyone started eating pastries and 2 hours later, we settled." He specializes in business, labor and employment, entertainment, personal injury, and real property. Last but certainly not least, we have Mr. Max Factor III, who has been a full-time neutral since 2000. Mr. Factor has mediated several disputes in the entertainment and IP field. He is often known as the agent of reality within the conference rooms of a mediation. Mr. Factor specializes in business, employment, entertainment, IP, and real estate. Before we start, I did want to mention we will do a Q&A at the end of the program. Please feel free to post your questions at any time, but we will answer them at the end. And I'm going to go ahead and hand it over to Mr. Jeffrey Kravitz.
And Nicole, thank you very much for that kind introduction. And thank you everybody who's joining us on Zoom. It's an important alternative to sitting in your house and worrying about when we're going to get out of this situation. Speaking of which, I'm reading a book called A Distant Mirror. And the subtitle is The Calamitous 14th Century. One of the themes of the books is the pandemics of the 14th century. And part of what they remind us of in the book is any number of good things that arose during the pandemic. And I think Exhibit A would be the Italian Renaissance, where the city-states of Italy became worldwide trading states. And part of the way that they did that was by ensuring that the ships that came in from the Middle East and the Far East were stationed on an island for 4 weeks. And that is the source of the word quarantine, which we're all using. It is also a useful reminder that Hamlet and other Shakespearean plays were written during the pandemic in England, which means that even though we are facing challenging times, some of the things that will emerge in the entertainment industry are going to be useful for everybody. So let's take a look at a couple of those. And I'd like to lead off with perhaps my favorite new venture, which is a company that's out of Great Britain called Film Chain. Film Chain was started by two Romanian women who had had time in both Lloyd's of London and the stock market in England. They were seasoned people in the film industry as well. And part of what they were noticing is part of what you folks have probably seen in your practices, which is that getting royalties from overseas is absolutely problematic. And they wanted to come up with a better way to collect royalties from overseas. One of my clients was a gentleman who worked for Chubby Broccoli, the guy who did the first James Bond films. And his job as a young man was to go to movie theaters in Italy. He would make it so that he was the first person to buy a ticket. He'd go in and he'd wait until the film started and he'd become the last person to buy a ticket. And lo and behold, he would find that perhaps the movie theater was underreporting the royalties that they should have been reporting to Broccoli. Well, that still happens, and Film Chain was started to rectify that situation. What you have, and the impetus for that, was that there are any number of funds in Great Britain, in Canada, in various of the United States, where public money is being used to finance motion pictures. And whereas it may be cowboys in terms of the industry, the public regulators were taking a look at this and saying, we're getting cheated on the royalties. We're not seeing as much money as we should. Hence, Film Chain got started. HBO is probably the largest company that is enrolled with it. And what it is a dashboard that everybody involved along the sequence from start of the film through release and post-production has to sign on to. You open up the dashboard and you see everybody's books at the same time, which means that if royalties come in Romania, they're going to be posted immediately in either dollars or euros on the chain and on the dashboard, so that everybody knows what's going on at every stage, and so that more royalties can and will be collected. I spoke with one of the two founders who had work at Lloyd's, and I've done work of Lloyd's of London myself, and she said, you know, it was an open secret for years that the brokers who collected the most money for the lawyers' fees let it park for a while in their accounts and made a little bit of money themselves before they passed the money on to the law firms. She said that's part of what we're trying to rectify here, because money does get collected in Zimbabwe, in China, in Romania, and it oftentimes sits with a collection agency until they can arbitrage the situation. So, Film Chain to industrious young women starting a company where it's become part of the heyday of the pandemic. And the other thing that obviously goes along with that is that we're not seeing each other as much as we usually have in the past, which means that everything is being done electronically. So I pass that on to you. Let me talk about another proposed venture, and there was an article on this in the Hollywood Reporter in the other days, and the talk was about biometrics of athletes. I don't know how many of you saw, but the NBA had its first 2 games yesterday, and the proposed biometrics would be betting on, say, LeBron James's heart rate. What is it at the beginning? What is it at end? What's the high? What's the low? The bookies in London have to be salivating over this in terms of the possibilities. But it does raise any number of interesting questions. One, of course, is who owns it? We've already had a case involving LeBron James's tattoo. Question is, does the player own it? Does the league own it? Does the network own it? Do the bookies own it? It sounds like a lawyer's paradise and perhaps lucrative for days when we're not going to be able to go into betting parlors or so easily go to Las Vegas. That's part of what's going on in terms of the upsides. Part of what's going on is simply how we're going to be doing business in difficult times. It was in the Los Angeles Times yesterday that Universal just signed an agreement with AMC movie chain, and the agreement provides for a modified holdback. It used to be that if you signed a contract with AMC, they got X number of cycles before you could release the film on a different platform. Well, AMC is on perhaps the verge of bankruptcy itself and is most anxious to arrange for additional revenues to come in. So as part of the deal, what they have agreed to is that they will participate in the next sale, the next round, which means if they have the new Spike Lee film, they're going to get it for 17 days without competition. Next thing that may happen may be that Universal or whoever the releasing company is goes to Netflix And whereas they might have gotten 100% of the deal before this agreement, you're going to have AMC participating in the agreement itself. Just kind of an interesting way to do business in challenging times. Along that line, I have a client who is already doing avatars of actors and actresses. By that, I mean he will go, he will film him or her, and he will record their voices. And the reason that this is being done is, let's assume that you're Ryan Reynolds and your agent gets a phone call from Sapporo Beer Company over in Japan. And Sapporo says, we would like for Mr. Reynolds to do a commercial for us, and we're on a bit of a timeline, so when can we fly him over? Well, the immediate answer is you cannot. But the long-range answer will be something along the lines of he cannot do it right now because he is busy filming up in Big Sur. But if you have the avatars for Mr. Reynolds, you can use those, license them out such that he can do the beer commercial in Japan. I'm told that you can even use this for foreign languages, although it gets much more tricky than that. What are the challenges? Who owns the avatar? Does the actor own the avatar? Does the licensing agent own the avatar? It remains to be seen what the unions are going to have to say about that. And of course, their concerns are not the supplement to the actor or actress's income, but the replacement of the actor or the actor. We've already seen virtual concerts being held with avatars of performing artists who have died. I've talked with a couple of actors, and believe it or not, they are cautiously optimistic. And the reason is anything that can add to their bottom line, they think will be helpful. Which brings us to the next question, which is affecting labor out there. And that is the question of waivers. Nobody wants to go back to work if it means that they're going to be exposed to the virus. By the same token, Hollywood has to go back to work or it becomes irrelevant. So there has been a proposition that has been put out to any number of lawyers around town to just draw up a waiver and I'll have somebody sign a waiver before they go back to work. Well, most of the attorneys that I have talked with find them absolutely problematic. And the reason for that is multifold. For years, I did work for railroads, and in the railroad business way back when, there was what was known as a yellow dog contract, which was a glorified waiver. It tried to get the railroad worker to prospectively waive any liability if they were injured on the job. Well, those were uniformly declared illegal, and therefore you don't see those. So the waiver presents the same sort of issue. Is there going to be any legality attached to it? Now to the other point, which the studios are going to have to consider. If they are considered to be legal, traditionally, the sole remedy for somebody who's hurt on premises during filming would be workers' compensation. If you have now tried to execute a waiver, have you voided out the possibility of workers' comp as an exclusive remedy? Not only that, there's also the tricky matter that Max and I discussed, which is most of the labor agreements that you see involving talent are not in the name of the individual artist, but are in the name of his or her loan-out company. So you can have a loan-out company sign a waiver, then if the artist gets injured, she or he simply says, I didn't sign it, that was signed by my loan-out company. It doesn't have any effect. So what are we going to be doing before we start filming? And one of the many avenues that I have talked with people about is the expansion of esports, which frankly leaves me personally cold, but enthuses my son and any number of his friends. And for those of us who have not partaken, esports is basically gaming on screen with people attending as though it were an athletic event. So, for example, it is huge in Korea. Before the pandemic, they would fill out 15,000 seat sports arenas and have people attend with excitement about the people who are playing. Well, what's the advantage during a pandemic? Number one, the players don't have to be in the same room. They don't have to be in the same country. They don't even have to be in the same continent, but it does need to be live. Likewise, obviously, the audience can be huge and can be worldwide. So I think we're going to see that expanding, although so far there have been sports leagues in the United States, and they have not been particularly profitable. But let's take it a step further and see if we can wed sports to entertainment. And by that, I mean, how many people in Britain would be interested in hearing Prince Harry announce a virtual soccer game between teams that's online? How many people would be interested in seeing the next flame from records, from movies, from television shows announce a game? It's a way to cross-reference and gives new meaning to the expression second screen, which has proven to be profitable in the United States, where somebody gives commentary of a live event without being part of the event itself. And that has proven to be a useful way to make additional money for people who are knowledgeable in the field. Which segues to podcasting, which is not a new idea, but relatively new, and one where there is ample room for expansion. Survey was done last year and found that 51% of the viewing audience in the United States had watched podcasts, which leaves us 49% who haven't. And I found the numbers to be staggering given that. 2019, the projection was that some $679 million was made off of podcasts. Obviously, the advantage that that has is you can listen to them while you're in your car or traveling or just want to lie on your bed and not be part of a Zoom meeting. And again, it gives the entertainment industry a separate platform for perhaps LeVar Burton to be reading Autobiography of Malcolm X with commentary by civil rights leaders, or a feminist who wants to talk about the progression of the feminist movement with Taylor Swift giving her impressions of what should be going on. So their other advantage of podcasting is compared to filming, it has very low barriers to entry. It's going to cost a fraction of what it would cost to film if you want to do a podcast. So we may be looking to podcasting in terms of future revenue streams. Now, the question is, with the pandemic facing us, is there insurance for any of the business stoppage that we have seen? One of my areas of concentration has been insurance, and my best guess is that it's going to be awfully difficult to prove that there is insurance, because business interruption insurance generally requires a physical manifestation, and that doesn't mean that somebody's gotten sick. The insurance industry will fight like hell on this one, and I have already been part of meetings where insurers have talked about their concern that the legislature in New York is talking about retroactive coverage wiping out the exclusions for pandemics. And they've said, well, they can wipe it out. And part of what's going to happen is if they wipe it out, it's going to wipe out any number of insurance companies. You wipe out the insurance company, who's going to pay? It generally goes into an insurance guarantee fund, which in most states only provides a fraction of the coverage that you would get if it was a live insurer. I believe last time I checked in California was some $375,000 per claim. Well, you might say most insurers have reinsurance. That's true. But 95% of the insurance policies lack what's known as a cut-through clause. A cut-through clause would allow the claimant or the insured to go against the reinsurer. And the law on that throughout the United States has been that cut-through clauses are legal, but there is no requirement for a cut-through clause. And that absent one, you're not going to be able to go after the reinsurer. Which brings us to the possibility twofold. Number one, the possibility that Congress is going to pass some form of limited liability. I will leave it to my colleagues to discuss that. Or that they're going to try to ape what was done at 9/11, which is to establish a fund and try to have an Übermensch act upon the fund and act as a pseudo-judge and try to mediate or arbitrate the disputes. The fly in that ointment is we're not talking something where there were 3,000 victims. We're talking about something where there are millions of victims in one fashion or another. And I don't think that society is going to bear up under that scenario. So where does that leave us? It leaves us with any number of alternatives. For example, for tech, we are on Zoom. There are other platforms. I think that we may see a consolidation, but my experience throughout my years of practice has been that when you have consolidation, eventually you have smart, creative people bleed off from the company. In fact, that is how Zoom got started. Their chief executive was an executive with Cisco. He came to them with a prospect of it, and they said, "Now we don't want to get into that." So I look for two directions. Number one, I look for the possibility of consolidation, and the names that are being floated are everything from MGM to Roku. But I also look to what I call Kravitz's law, which is bleed off, that you get enough creative people being told no in an enterprise that eventually what they're going to do is, the heck with it, I'm going to start my own venture, which doubles back on the initial thought that I had, was that creativity can prosper during a pandemic. So let me close with a Goldwinism. Samuel Goldwyn was the G in MGM, and he was famous for his malaprops, things such as, "I will never talk to you again unless I need you for something." So the malaprop on which I will end and turn it back to my clients is, as we get back to business, everything's going to be absolutely the same, but it's going to be completely different. So let me turn it back to Peter and Max at this point.
Peter, you need to unmute yourself. There you go.
My impression was, Max, you were going to go next, but I'm happy to proceed. It's up to you.
Please.
All right. Well, greetings. Good afternoon, everyone. My comments, my remarks probably will be best characterized as something in the nature of a nuts and bolts overview of the intersection of certain legal concepts with the concerns that have arisen by virtue of the pandemic. Now, what follows, to say the least, is not exhaustive. The very nature of the subject matter makes it virtually impossible for it to be exhaustive, but rather the objective will be to highlight certain subject areas where questions may arise and to direct you to selected resources which will, at the very least, provide a starting point from which you may address those questions and hopefully find adequate responses. Now, before I begin, I should state that virtually everything I'm going to speak about is set forth in the outline which I've prepared which is, I believe, begins at page 9 of the materials, which I believe have been provided to you by the Beverly Hills Bar. So as I referred to various guidances and rulings and occasional statutory material, don't be worried if I don't mention the citation or if I run over it rapidly, and don't be worried about trying to scribble all this down and get it right. It's all in the outline, and ideally you should be able to link directly from the outline to a whole variety of resources which have been created in response to the pandemic. So let's begin with some general thoughts and concerns, and also a sampling of some of the references, the reference material that's available to you out there. First of all, I don't think I need to state that the COVID-19 situation is very fluid. It changes almost daily, and therefore it's essential for anyone acting in this field, anyone advising clients in this field, to engage in what is virtually a continuous review of the status of the pandemic. And you start by referring to pronouncements and guidance and observations that have been issued by everyone from the CDC, and you must consult with the CDC, and also local health authorities. This is particularly true for business entities which may be operating in various jurisdictions, as is often the case in film production. And so you'll, for example, here in California, you'll need to consult, if you're in LA, you'll need to consult with LA's guidances and requirements, the city, the county, the state, and we're going to talk about some of the state matters in particular, and of course the federal. And the CDC is the place to begin, and again, their website has certain information directly related to this, and you really need to consult with that. The EEOC is also active in this area and has issued certain guidances, and I'm going to just read you, it's too long to remember, I'm going to read you the title of one that's very important, and again, it's all in the outline. It's called What You Should Know About COVID-19 and the ADA, the Rehabilitation Act, and Other EEO Laws, and you can link to it directly from the outline. And the EEOC has weighed in on this, and it's important because here we're talking about, and we're going to talk about in some detail, the application of statutes and various prohibitions against discrimination and how that intersects with the COVID-19 situation. Also, you need to be aware of what is coming out of Osha, both the federal Osha and the state Osha. And very relevant here is what is called Osha's General Duty Clause. It's found at 29 USC 654. It's in the outline. And it provides that each employer shall furnish to each of his or her employees employment and a place of employment which are free from recognized hazards that are causing or are likely to cause death or serious physical harm. And also the employer is obligated to comply, of course, with all occupational safety and health standards which are promulgated. The employee, on the other hand, must also comply with occupational safety and health standards. And this is all in the General Duty Clause of Osha. And that becomes relevant, as you will see as we go through some of the questions that are likely to arise. And it's very important. And again, Cal OSHA has also weighed in on this, and you can go to their website as well. I'm going to just mention a few additional resources before getting into some particular questions. First of all, in addition to the EEOC, you have what is essentially the state counterpart in California, which is, of course, is the DFEH, and they have weighed in this on as well with their own information on COVID-19. Secondly, a number of industry guilds and other entities have issued all kinds of protocols. And I might mention here parenthetically, there was an article in the Times this morning, LA Times, about a production which just wrapped in Atlanta, in which they had 30 pages of protocols and all sorts of procedures that they took. They flew the cast and crew in on a private plane after 2 weeks of quarantine. I may have this backwards, but just by way of illustrating the length to which they went in shooting this particular film. But anyway, just to give you an idea, the International Cinematographers Guild, Local 600, has issued some recommendations, and they are stated to be in addition to interim guidelines and health and safety protocols issued by the Alliance of Motion Picture and Television Producers and their industry-wide Labor Management Safety Committee. So those you'd almost necessarily want to look at if you're even considering some production. And look also at something called the Safe Way Forward, which is a multi-union report on COVID-19 safety guidelines issued by the DGA and other guilds. And SAG-AFTRA, I know, I've seen they have a whole list of requirements and concerns relating to the pandemic. So those resources are out there, and they will be it's obviously imperative that you consult them if you're going to do anything in the production area in the next several months at least. Now, the EEOC, the questions here that are perhaps most important are concerns about discrimination in the context of the pandemic. And the EEOC has made it very clear in the guidance that I mentioned a moment ago, and they say that, in a nutshell, all the anti-discrimination laws continue to apply. And you will see as we go through some of the questions that it really is more complementary than contradictory. The EEOC has issued another guidance entitled Pandemic Preparedness in the Workplace with the Americans with Disabilities Act. And this was actually written a while ago with respect to another virus, but it's been updated and it's still applicable. And this publication notes that the ADA is still relevant and is very relevant in pandemic preparation in at least three major ways. First of all, the ADA regulates disability-related inquiries and medical exams, and we're going to talk about that, for all applicants and employees, including those who are not disabled. Secondly, the ADA prohibits covered employers from excluding individuals with disabilities from the workplace for health or safety reasons unless they pose a direct threat, and we'll talk about that as well. And thirdly, the ADA requires reasonable accommodation for individuals with disabilities, as you all know, absent undue hardship. Now let's talk about some specific situations that are likely to arise. There are a million variations on this, and I want to state at the outset that virtually everything we're going to talk about is fact-specific, particularly in the situation with the pandemic, when you have so many varieties of factual circumstances which could exist in any given situation. So keep that in mind. You have to be very fact-specific when addressing these concerns. First question: when hiring, may employers screen applicants for COVID-19? And the short answer is yes. The EEOC has specifically stated that an employer may screen job applicants after, and this is a critical word, after making a conditional job offer. That's basically consistent with existing law. But it must do so for all entering employees in the same type of job. You also need to consider Osha in this regard. And here again, it's really important to monitor the CDC website among other health authorities, particularly as symptoms may frequently expand or otherwise change. So you have to know what you're looking for, and it may be different on any given day. So again, it's a question here in this pandemic of constantly monitoring the available resources. Second question: may an employer delay the start date of an applicant who has the virus or symptoms associated with it? And the answer here again is yes. The CDC says in plain and simple terms that an individual who has the virus or symptoms associated with it should not be in the workplace. Period. End of story. And you will see the CDC guidance that talks about this. And again, this all may change, so you've got to monitor the website. But what's important to repeat, and I'll probably repeat this more often than I should, but the ADA does not interfere with employers following recommendations of the CDC or other public health authorities. Excuse me. Next question: may an employer withdraw a job offer when it needs the applicant to start immediately, but the applicant has the virus or symptoms? And again, based on the CDC guidance, this individual cannot safely enter the workplace. And so the job offer may be withdrawn, and the EEOC has weighed in on this as well. Next question. May an employer postpone the start date or withdraw a job offer because the individual is 65 years old or pregnant, both of which can place them in a higher risk, at a higher risk for the virus? And the answer here is no. The fact that the CDC has identified those who are 65 or older or pregnant as being at greater risk does not justify the employer in unilaterally postponing the start date or withdrawing the job offer. However, what's recommended here, it's good practice, I think, is for the employer to communicate with the employee, engage in something in the nature of an interactive process, see if telecommuting is possible or some other arrangement that will make the employee feel more comfortable. I'm going to give you a little personal aside here to illustrate how fact specific this is and how you have to really be attentive to what the CDC is saying. As we all know, the older folks are deemed to be more vulnerable. And the reason is because as you get older, arguably your immune system doesn't function as well as it used to. Now, I'm in that category. I'm well into that category. But I never get sick. I virtually never get sick, which is to say my immune system seems to be functioning quite well. So I asked my doctor about this, and he put it in very basic terms. He said, look, the older people who are vulnerable, are deemed vulnerable, are older people who are frail. That's the term he used. And he said, you're not frail, don't worry about it. And that was the end of that. So again, each fact situation is different. And an older person who is healthy and doesn't get sick may not, in fact, be as vulnerable as other people who are of mature years, shall we say. Now, the ADA prohibits employment discrimination, ADEA, I'm sorry, prohibits employment discrimination against individuals who are 40 or older, as we all know, and it would prohibit an employer from unilaterally excluding an individual from the workplace based on age alone. And the EEOC notes, even if the employer acted for benevolent reasons, that is to say, looking out for the welfare of this older employee, it's not permitted, although you should attempt to engage in something in the nature of the interactive process to try to address that. Interestingly, employers are free, in line with this, to provide flexibility for workers who are over 65. The ADA, of course, does not prohibit this. But what's interesting, it doesn't prohibit it even if it results in younger workers being treated less favorably based on the age involved. So that's an interesting little twist. Next question. May an employer under the ADA require employees to stay home if they have COVID-19 symptoms? And the answer is yes. Again, going back to the CDC, employees who become ill with symptoms should leave the workplace for obvious reasons, and the ADA does not interfere with this. And the DFEH is in accord. Again, the references are all in the outline. Next question. I'll take a sip of water here. During the pandemic, may an employer take an employee's temperature to determine whether they have a fever? And normally this is what's deemed a medical exam, which, as you're probably well aware, may only be performed by an employer or a prospective employer under very limited circumstances. However, based on CDC and local public health information and guidance, employers may measure an employee's body temperature for the limited purpose of evaluating the risk that that employee's presence poses to others in the workplace. And the DFEH has spoken to this as well. Now, a little kind of a caveat here. Temperature checks by employers may require notice to affected employees pursuant to the California Consumer Privacy Act. Legislation which became effective at the beginning of this year. It's set forth in a civil code. Be careful about that. You need to look at that if you're going to be taking temperature. And of course, the temperature may be taken as part of a post-offer pre-employment medical exam. Medical exams, as I believe you all know, are permitted after an employer has made a conditional offer of employment. And here again, everything is fact-specific, particularly in this area of inquiry. Some people with COVID-19 do not have a fever. So the temperature check is not a be-all, end-all, or whatever the appropriate term is, for assessing the appropriateness of any given individual's presence in the workplace. Next question. May an employee decline to travel on work-related matters due to COVID-19 concerns? That's obviously of concern if you have a shoot that's in another state or somewhere that requires some sort of travel. Again, this is very, very fact-specific. And here we go back to Osha's general duty clause mentioned earlier, which provides that an employer must furnish a workplace free of recognized hazards that cause or are likely to cause death or serious physical harm. Thus, arguably, conceptually under this concept, how's that? Arguably, an employee may refuse to work in a particular situation by virtue of a factually based concern that he or she is in imminent danger of infection where the employer cannot address the specific concern. Now here, you must look at California Labor Code section 6311, which provides that an employee may refuse to perform work which would create a real and apparent hazard to the employee or his or her fellow employees, and which would violate the labor code or any occupational safety and health standard or safety order. So it's an area where you have to tread lightly. If there is if it's plausible that the employee may be exposed in traveling on work-related matters to the COVID-19 concerns, especially if the employee can point to specific problems with the virus in whatever the area is to which he or she will be traveling, the employer acts at his or her peril if they simply blow that off and don't respond to that concern. And again, engage in some, the most appropriate way to pursue this is to engage in something in the nature of the interactive process. And here it's important also to note that so far Osha has not set out, referring to the California Labor Code section 6311, the right to refuse dangerous employment, Osha has not set out definitive examples of the right to refuse, nor has the right been included in its guidance about COVID-19. So the general recommendation has been that if employee has these concerns, he or she should consult directly with Osha and get their thoughts on it, and then go to the employer, depending on the outcome, assuming the outcome of that supports it. Next question. When an employee returns from travel during a pandemic, must the employer wait until the employee develops symptoms to ask a question about exposure to the pandemic during the trip? And the answer is no, the employer doesn't have to wait. This would not be a disability-related inquiry, so the discrimination statutes really don't come into play here. If the CDC or state or local public health officials recommend that people who visit specified locations remain at home for several days until it is clear that they don't have the pandemic, an employer may ask whether an employee is returning from any of those locations, even if the travel was for purely personal, private reasons. Next question. May employers administer COVID-19 tests before permitting employees to enter the workplace, the physical workplace? And the answer is yes. Given the pandemic, the EEOC has concurred. And note that pursuant to the ADA, employers are responsible to ensure that the tests are accurate and reliable, and mandatory employee testing must be job-related and consistent with business necessity. Next question. During a pandemic, may an employer require its employees to wear personal protective equipment, face masks, gloves, and gowns? And as you might have assumed, the answer is yes. Be attentive, however, to concerns of disabled employees who may need reasonable accommodation, for example, non-latex gloves. And so this accommodation should be provided by the employer absent undue hardship. Next question. During a pandemic, may an employer ask why an employee is absent from work if the employer suspects it is for medical reason? The answer is yes. The Eeoc has opined on that. And it makes sense if you're being proactive and cautious with respect to spread of the viruses. Of course, you should be. Next question. Is an employee who is not eligible for sick leave still entitled to accommodation if he or she cannot come to work due to a COVID-19 related illness? I think most people who practice in the area of disability discrimination would argue, if nothing else, the employer would be prudent to offer that accommodation, and that's certainly my view. Here you would treat the employee as at least possibly or potentially disabled and engage in the interactive process. Again, as I've noted earlier, the Eeoc has stated that all these statutes continue to apply during the time of the pandemic, but they don't interfere or prevent employers from following guidelines and suggestions made by the CDC and other health authorities. Next question. What if an employee refuses to report to work because they object to taking public transport, live in, or must travel through what's a so-called hotspot, or have other such virus-related concerns? And again, it appears that employees who are simply apprehensive about COVID-19 may not refuse to do so. And if they nonetheless refuse to report to work, the California Employment Development Department, I believe, has indicated that such employees may be precluded from collecting unemployment. However, if the employee presents, factually verifiable concerns, or if the employer fails to undertake mandatory safety measures, employees may have good cause not to return. And once again, the employer would be prudent to engage in something in the nature of the interactive process. It may be remote working or something of that nature. I keep referring to the interactive process. I think most mediators who do employment work will agree with my observation that most of the disability discrimination cases I've mediated could have easily been avoided if the employers had been aware of a two-word phrase, which of course is interactive process. If they'd engaged in the interactive process, in most of those cases, that would have been the end of the story. Litigation would never have been initiated, or the dispute would never have arisen. And so it's a question of really keeping if you represent employers, it's important to really keep your clients aware of that process. It's not difficult to implement, and it should be documented, and it can save them an awful lot of grief and an awful lot of money for that matter. Now, getting back to this question, if an employee refuses to work, here again, you have to refer to California Labor Code Section 6311 and Cal OSHA, which I discussed a few moments ago, which of course provides that the 6311 provides that the employee may lawfully refuse hazardous work. I'm looking at my time here. I've got a few more minutes. It's clear I won't be able to cover all of the questions, but they're all in the outline. But I'll pick a few that I think are particularly relevant. May an ADA covered employer require employees who have been away from the workplace during a pandemic to provide a doctor's note certifying fitness to return to work after the pandemic? And the answer is yes. These inquiries are permitted under the ADA because they're not really disability related. And even if they would, and they would be justified under ADA standards if the pandemic were truly severe. And I think if it isn't truly severe, I don't know what it is. Okay, workers' compensation. Jeff alluded to this a bit in his comments. something very interesting has developed. I was thinking about comp, and I was thinking, well, if an employee comes down with the virus, how do you establish if it was, and assuming he or she was working at the workplace, how do you establish that it was contracted at the workplace? Well, the governor answered that question. In May, Governor Newsom signed an executive order, which creates a rebuttable presumption that any COVID-19 related illness of an employee shall be presumed to arise out of and in the course of employment. That, of course, is the standard for the applicability of workers' comp. And that executive order also provides that where, and this is important, this question has come up quite a bit, where the employee has paid sick leave available concerning COVID-19, that paid sick leave must be exhausted before the employee is entitled to receive temporary disability benefits under workers' comp. If the employee doesn't have paid sick leave, obviously then the temporary disability begins forthwith, but first any paid sick leave which does exist must be exhausted. Now there's a very, very critical exemption that you may have guessed to this presumption. And while the presumption applies where the employee performed labor or services at the place of employment, but it implies only where the place of employment was not the employee's home or residence. So if he or she is working at home, the presumption does not apply. Jeff talked a bit about liability waivers. This rebuttable presumption under workers' comp may, to some degree, erase the need for such waivers. And I concur with Jeff that I think it's problematic at best. These waivers are problematic at best and probably bad public relations as well. I'm just about out of time. The only thing I want to mention, one other matter, because Jeff touched on this also, and that's the question of insurance. I have been hearing that insurers, that you should, well, let me start at the beginning. Check if you have business interruption coverage and coverage of that nature, check your policies carefully, particularly at the time of renewal, because I've been hearing that insurers, the carriers are reporting adding virus and pandemic exclusions to their renewal policies. So scrutinize very carefully your renewal policy if it comes up. The rest of what I was going to say is in the outline. All the citations are there. Thanks very much.
Thank you, Jeff, and thank you, Peter. Partly out of time, I really want us as a panelist to be able to answer your questions. So I'm going to keep this down to 5 or 10 minutes because I can always say the same thing in answer to your question. That's what politicians seem to do so often. Ask a question about A and then the politician says what they want. I promise not to do too much of that. It says on my website, I'm an agent of reality. That's my Rosetta Stone, my touchstone when I'm negotiating. When I was practicing law and the last 20 years as a mediator and arbitrator, private judge. So I want to start with the obvious. We're all going to adjust to this. We're all going to adapt. For some people, we know the adaptation is going to be chronic illness or even death or grieving and depression. We know that. Everybody, at least on this panel, I think was alive and well when polio was a pandemic in the early 50s. And, every time you wanted to go out and play on the street with your friends, you got to look from your mom, and your dad was working in those days, and you got to look who you playing with because of this concern, because of the invisible polio virus. And many of us got sent away to camp because then we wouldn't be in the cities with polio. So let's start with the reality that a lot of harm and tragedy is going to be caused. But each of you are here on this webinar because you want to learn something to be more productive as professionals and as individuals. So there are two things I'd like to do in a hurry, which is while I'm talking, if you can go to the chat room or something, and if you could just jot down, each of you who choose to do so, what are your goals for being here? I'm going to make some assumptions so I can keep this short and brief. But why are you here? What do you want to learn? Do you want to learn so you don't get sued for malpractice because of what you said to your client? Do you want to learn because you want to be the equivalent of an HR person who's an expert in this and the go-to person? I use a better word, I think, than an HR person. Just like virtually all the law firms people are listening as lawyers, you have a tax specialist, and if it's not within your firm, you have a relationship, a correspondent relationship. So when you enter into an entertainment deal, you know exactly who to talk to get the tax coverage to protect your client. Well, I think most firms are going to need to have people to deal with these pandemic issues, and they're going to need answers immediately, and they're not interested in people doing research. They're not even interested in people who have to go check the CDC or NIH or Osha or FIHA or any of the other guidelines. They want experts who will give them an answer to the question they asked. The first question that was asked in the Q&A is, what about waivers for independent contractors, such as third-party vendors? So that's what our clients are going to be asking us about. So if you take anything away in terms of a goal here, it might be okay to be a bit learned about these issues. I think the most important thing you can do is have a specialist or become the specialist who can answer all these questions and answer them quickly and clearly. Anything short of that, I think will expose you to be less competent and less effective for your clients and cause more disappointment than you ever wanted to cause to your client, because these are life and death situations or chronic disability situations, as we're learning. So the second thing is, all these systems will adapt. We all lived through 78 records and 33 records and having a little insert to put in the 33 records so you could play it on your 78 phonograph and so forth. And maybe not the people listening to me, but I surely did. And then we lived through VHS, and I'm not going to go through the whole litany. So that's what's going to happen with this pandemic. We're going to evolve, we're going to adapt, we're going to have solutions. Absolutely, every insurance policy you touch now has an exception for terrorism. No problem at all. For $250, you get your terrorism insurance. In the next 6 months, every policy will have a pandemic exception, and no problem at all, you can pay more money and get your insurance. This is how institutions and societies morph. This is Joseph Schumpeter's creative destruction. And if there were ever a place where people have imagination and creativity, and I might add to that, are fully prepared to leave their studio or their production company to start their own, it's the entertainment industry. Writers, directors, producers, talent. So don't be concerned there are going to be no answers to this. There's going to be lots of innovation and lots of solutions. But in this interim period of the next few months, find yourself an expert or develop that expertise yourself. And this seminar that you may have paid $5 for or whatever will be very valuable, especially if you're the one who becomes the expert in one of these areas and can answer the questions. Waivers, I do want to address that briefly. They're always anti-client. They're exactly the same. If I can say, is when you're required to have a written agreement with your client, and when your client reads the written agreement, they're almost always annoyed at you at some level. You really mean that if I don't object within 30 days to some item on the bill, I have to pay it or I can't sue? And they read this in every which way, and they're kind of offended that your interest is in protecting yourself. Why you wouldn't protect yourself, I don't know. And in the case of being an attorney, you need the written agreement for compensation. Having said all of that, waivers are a necessary evil, and I believe that the wisest thing you can do is write your waivers so that they don't read as an attorney. They read as a humanity, with some humanity, some empathy. This is a document we need to give you because there is a chance you're going to be exposed to this and this. And within the work environment, we have workers' comp and we have a set of rules. But when you're a third-party vendor, we don't have the same set of rules, and we we need to know what our risks and rewards are, and so do you. And so this document is going to describe that. And if you're uncomfortable, we need to have a discussion about it. Don't sign this waiver. We need an interactive discussion about what your discomfort is. And we need a process so when some of these things come up, you can immediately have a discussion with the right person in our firm or in your entertainment business or whatever it is. I think that should be the tone of the waiver, because you're dealing with such important issues and you're dealing with deep-seated fears here. You know, the fear of dying or the fear of a chronic illness. And for most of us, even an equally large concern, none of us want to carry a disease, give it to someone else. We may even be symptomless, and that person has a chronic illness or loss. So when you're dealing with something that important, don't treat it as a waiver, as a piece of paper. Treat it as what it is. Tell the person you're handling, this is why we're doing this, and we have this process, and we have in our firm, if it's a law firm, a specialist. If it's you, that's terrific. And in the business, the production company, the studio, whatever, here is the name of the person to have an interactive discussion. If it's me, I don't represent studios that way, but if it were me and I see people, I've certainly talked to agents and so forth, I tell them, you have an answer person. You be interactive. Don't rely on a waiver. The real estate industry's got a terrific waiver. I don't know if any of you gone to an open house or something. You sign, please give me COVID. It doesn't bother me at all. I'm fully prepared. I have all the medical, and it's not a deal for me. Okay, we don't need waivers like that in the entertainment industry. That's just disrespectful. So there's going to be liability. There are going to be losses. And the important thing is we tell our clients, you have to behave in the same way as if you had an attractive nuisance right on your website. You've got to protect people. Believe me, Disney knew they had to protect people with all those rides that they had, and they learned how to do it. And we need to help our clients protect themselves. Okay, so that's sort of the end of that. I'd just like to say something about the changes. The industry changes are going to be very substantial. Podcasting was a good example. Esports is another. I just paid £10, 76 pence, I guess it was, on the How To Academy because I wanted to hear Michael Sundell speak. Michael Sundell used to speak for free. Now he's doing podcasts, with 10,000 people listening. So there's no question that podcasting will become an integral part of entertainment. No question it's going to be on our TVs right next to Netflix and Hulu and so forth. And we had pay TV for almost a decade before it sort of disappeared. I used to like professional boxing, so I had to pay to see the championships. And some of them were expensive, but you did it. Well, it'll be back in one form or another, except with digital. We all know you just click a box. You don't even have to tell your anything now anymore. So it'll be a very efficient process, and you'll pay for what you get. We have pay or play movies, right? So why are we not going to have podcasting and esports and all these things on a pay basis again? The entertainment, people love it. It's just real. We're going to have it. Our jobs, well, I'm not practicing law anymore, but our jobs as an attorney, protect ourselves, our family, and our law firm from getting sued for malpractice because we're not as competent as we should have been, and we didn't take care of our clients in the way we wanted, and learn how to do that. That, I think, is the primary purpose of having this webinar. So, and let's take some questions. Is it Peter or Jeff? One of you is going to step up and handle those. Here we go.
I'm happy to yield to anybody, but I believe it was me. It's interesting. There have been a number of questions coming in about liability waivers, and particularly with respect to independent contractors. Any thoughts on that, Jeff or Max, or Max?
This is Jeff. I have some thoughts. Years ago, I handled a case where it was an industrial plant, and the roof was bad. I mean, it was in terrible shape, such that if you climbed on the roof, you could go through the roof and injure yourself. So they hired an outside contractor to go up on the roof to do the necessary repair work. They made him sign a waiver before he went up there. And sure enough, he got injured, and he got very badly injured. The upshot of that was the Court of Appeals held that the waiver was valid. And it was particularly valid because the outside contractor was somebody who was hired to fix exactly that which the risk corresponded to. So again, I'm going to second what is being said by Max, which is different folks, different strokes. Look at what you're trying to get waived. Look at who the, dare I say, object is of the waiver. If it's somebody who's coming in to repair something where it's a known danger, that's going to be one circumstance. If it's somebody who's a cosmetologist who's supposed to do the makeup on somebody, it's likely going to be different. So I think what you need to do is not have a one-size-fits-all, but give thought in each particular case, and frankly, consult your in-house or outside counsel before you wantonly have somebody sign off.
I agree clearly. I love the cosmetologist example. I just speaking yesterday with a photographer who won't do any shoots because he has 3 or 4 people he needs, and including a cosmetologist. And he simply won't expose people he's worked with for 25 years to whoever walks in the door. And when we were talking, I suggested, in every industry, you're employing people who have expertise. Cosmetologists, you have the costume people, design people, and so forth. And I think when you're talking about a release, you need to also think in terms of what is their industry. There's going to be a trade practices for cosmetologists and for hairdressers. That's a licensed trade in California. And so I think in this, what I'm calling user-friendly type of waiver, you raise the concerns you have as an ongoing business. Here's what we're worried about and what you are exposing yourself to and these kind of dangers, and there may be more. Don't refer to some federal regulation for what you're worried about. Tell them there are chronic conditions that can be disabling. There's, of course, death. There's all sorts of issues. I would say it in a user-friendly way, and I would also say to them, within your expertise as a cosmetologist, within your expertise as a camera person and so forth, within your union, what are your safety standards? Are you complying with them? Have you checked to see whether they're satisfactory for COVID? What are people's concerns? Please do that before you come to work. Your specific industry, your specific talent has thought about these problems in terms of the exposure you have. Check with your trade association, check with your licensing people. So I think it's okay to put that kind of burden on anybody who's got a license or who's a member of a union, to have them look to their institutional protection. Now, it's not going to protect you if it's not going to protect you. I didn't mean that as a Yogi Berra. However, it will protect you in terms of your ongoing relationship with that person who you need. That makeup artist is going to be on that shoot every day at 4 in the morning or 4:30 in the morning. And you want them to have a relationship of trust and respect with you as the production company. So I think it's very important to urge them to look at their own licensing background, their own trade, talk with people, and then once again, just to be quick, I do believe that every production company, every studio needs to have a designated person or persons who can carry on an interactive process that is individually oriented, because one person may have no children and another person may be living with their father or mother who's 86 years old and so forth and so on. And having that process where somebody can talk to someone knowledgeable about the risks. You may lose an independent contractor, you may lose, but you lose them and they respect you. because you lost them because their fears and concerns were legitimate, and they weren't willing to take that risk, and that was okay with you. And of course, you just ask them who they'd recommend anyway, because if they do a favor for a friend, they're more likely to come back to you.
You know, there's another part to the conundrum, and that is, I think we're all assuming that the outside vendor comes in and gets COVID as a result of something in the workplace. But the other part of the conundrum is there's always a distinct possibility that the outside vendor comes in and gives the virus to everybody in the workplace.
Good point.
And I think that's, again, part of the difficulties with waivers, which is that courts tend to look at situations where there's not equal bargaining power, and they will imply it, which means that if you demand a waiver from an outside contractor coming in, it may well be that you are waiving any potential liability that the vendor might have for spreading the disease in your workplace. Now you can say, gosh, if it's an individual who's coming in, they're not going to have any deep pockets, they're not going to have any insurance. You know, but what if it's the guy delivering the Amazon load? Okay, you're going to demand a waiver from Amazon? I don't think so.
Well, you won't get it. But this raises an interesting question.
Well, I was just going to say that, if I can interrupt just for a second, with a lot of vendors, it is the industry's responsibility to have the internal rules. That's what you need attorneys from the Beverly Hills Bar Association, to say when an Amazon package comes, it's only touched by X, who wears the gloves and puts it to age for 3 days because it's whatever, paper and so forth and so on. And if the industry is not going to set up standards that relate to the outside vendors and to protections, given that I view this as an attractive nuisance, and I think any court would at a minimum, that you're operating in a business where you're perhaps passing disease and problems to others. I think that industry, with every vendor, needs to have their own internal rules about how they show they're engaging in reasonable care in opening that package from Amazon and then providing the contents to whoever gets it. And I think anything short of that is bad lawyering by us. We shouldn't let our clients go out there and say, gee, it wasn't us, it was Amazon. We need to think of what reasonable care, because we are the attractive nuisance when we're employing the people and bringing in outside vendors to provide goods and services to us. Our food, for instance, our truck,
It gets back to
the RVs that they move into and so forth. So
I'm sorry, Max.
That's it. I was just to say, we're inviting people to get sick by working with us. And given that, we need to take every reasonable precaution and tell them what it is in advance, so people who say, I don't think those precautions are good enough, can make their own adult decisions. Can't have it a contract of adhesion. You have to let people have that choice in a process that's interactive.
Underlying all this is the question of classification of workers. One of the questions that chat box referred to a production in which virtually everyone in the production was an independent contractor. And so you have to be very careful about that, because AB 5 is still very much in effect and still applies. And it's, as you know, it's a very strict test for determining whether an employee is an independent contractor. AB 5, by the way, there's an amendment in the legislature now that hasn't been adopted yet, but may well be an amendment which would, among other things, exempt musicians in the recording process from the Dynamex, or Dynamics, I'm still not sure how you pronounce that, test, from the three-part test. But AB 5 itself is still very much in place and could have a substantial impact on production. Somebody put something, a very interesting question in the chat room, which is this individual indicates that it was his or her understanding that the presumption I mentioned about workers' compensation, about COVID-19 being presumed to been contracted in the workplace, that executive order, which contains that presumption, has expired. I'm not aware of that. I checked it about, a few days ago now. If anybody has any information about that, that would certainly be very helpful. Put something in the chat box. I'm not aware of that. Someone asked a question about how the Black Lives Matter movement impacts and relates to all of this. I can speak to the voiceover industry where I'm active, and that there is significant. Just yesterday, I saw something where some voice actors who have often been cast in parts for people of color, when they themselves, the voice actors themselves were not people of color, are now going to refuse those roles and urge that the casting directors and so forth engage people of color for those roles. And that's just one example, but my impression is, and I appreciate Max and Jeff weighing in on this, is that there are efforts in a variety of respects in the industry to incorporate these issues as they go forward, pandemic or no pandemic. Jeff or Max, you have any thoughts on this?
Yeah, I do, and obviously it transcends the few minutes that we have left on this. I am waiting to see what is going to be done, as is the rest of the industry. I think that things will be done now that, albeit may have been promised a few years ago and didn't come through, I think they're going to come through now. I think the demand is out there from the population as a whole. And it's not as though it is a marginal movement or one strictly by African American people. It's one that seems to be coming from the roots. And if there's anything the entertainment industry has been good at, it has been responding to the needs of its audience. And I think its audience is telling us and telling everybody now what it wants. It's a little bit different than what they've been getting.
Thank you. I think, once again, I'm a big believer in adaptation. We all remember that for years, animals were injured in movie productions, and now you would not see a movie unless it said at some point in the credits that this filming was done and no animal was injured. I mean, we all mentioned lots of movies where you just certain the animals were being injured, but they were not. And I think we're going to see the same thing with Black Lives Matter. I think we're going to see it with Hispanic. You're going to have a statement that all voiceover actors, for instance, were African American if that was their role and so forth. Obviously, you're not going to have any statement that says all crocodiles use crocodile voices. That's a joke for those of you who don't know in the audience. But I think that this is how what happens is metrics get created, and entertainment industry is so good at markets and understanding markets that they will post that kind of information, and then that will assure the continuation of the movement in that area to have what I'll call reality, African American voices for African American talent. So I think that's what will happen. If it happened for PETA and animals, it surely is going to happen for human beings and careers. And it's a market.
And it happened for smoking as well.
Yes, it happens for smoking too.
Okay,
In fact, you can't go to a play where they don't warn you about things.
I've received an answer to my inquiry about the presumption, the executive order concerning the workers' comp presumption. And there was a reply. Thank you very much. I appreciate this. And apparently I hadn't been aware of this, so I didn't notice it. The executive order expired of its own effect because it was only in existence. Its duration was for 60 days, but apparently the consideration is being given to a retroactive renewal of that executive order. And I would guess that that's probably what will happen. But thank you again for that response. There was a question about quick result testing and whether that should be used and how effective it is. And here again, this is a fact-specific inquiry. For example, in the article in today's LA Times about the production that just wrapped in Georgia, in Atlanta. One of the problems they had, according to the article, was that it took too long to get the test results back, and of course it delayed everything, as you can imagine. And again, here, I think it's incumbent upon you to check with local health authorities, to monitor what testing is available, to look at the CDC website, and to make some inquiries, because these kinds, no matter, say you plan for testing and all the other protections, if one of them, any one of them, results in some obstacles or poses some obstacles which hadn't been anticipated, your entire production can at best be delayed, if not somewhat sabotaged. And so it's sort of like shifting sands. You just have to constantly monitor. I've said this ad infinitum, and I'll keep saying it. You have to constantly monitor what is being discovered out there, what the scientists are learning, what the test manufacturers are able to develop, so on and so forth, and what tests are available, different types of tests that are available. Initially, some of them were defective, they found out. So you've just got to be on your toes. It's not the kind of precise answer you might want, but that's, I think, the most appropriate advice that we can give. I believe we've covered, I hope we've covered all the questions that are, and thank you, by the way, for the questions and some of the nice compliments that are appearing in the chat room and in the question and answer box. We appreciate that. I think we've covered most of those.
Oh, Peter, I just have to say something. Greg had asked, what about screaming on the set? How about actors, directors, camera operators? Greg, you've got a fine sense of humor. All that I can suggest actually is a technique we use all the time. When people are in their emotional state, and we see that a great deal in negotiations, one of the better ways to handle it is to ask them a thoughtful question that removes them from the part of their brain that's defense mechanism oriented and emotion oriented, and puts them in their cerebral cortex. So there are a litany of those questions, but it's, asking just quickly questions on screen, and it's probably a good idea to recognize you can't ever control the moods and emotions in the industry. But I've found asking questions, who would you talk to handle this if we weren't here filming? Who's your most trusted advisor? Now they have to think, well, is that my partner, my business partner, my spouse? Is it the director? And just that pause to think and then get an answer from them, then puts them so that you can say, what would they say about screaming and yelling when this could be endangering people's lives? And they'll answer you much differently than if you didn't ask that first question first. Because if they're screaming and yelling because they're angry and you ask them, don't you care about other people's lives? You can get them to scream again. However, if you ask them who they would talk with to solve this problem and what would that person say, and you put them in their prefrontal cortex, they often say, and would say in effect, that person would tell me not to scream because I could be endangering my colleagues here. So it's just a matter of moving them from their instinctive brain into their thinking brain. So
I'm going to be thinking about prefrontal cortex now for
But Greg, it's a wonderful question because we know how helpless we feel when these things happen.
Greg had a multi-part question. Greg, we appreciate that, and hopefully we've answered all of the different elements of it. And I believe we've answered all of the questions. We have just a few minutes for concluding, very few minutes for concluding remarks. Jeff, you want to begin?
Yeah, let me add to what was just said by Max, which is one technique that I use when I mediate is one that was pioneered by British intelligence, which was the more the subject started yelling and screaming, the more you lowered your own presentation. And again, it tends to work. People respond to cues and clues, even in difficult times and in stressful times. And I would recommend that demonstrating, number one, your own humanity, but number two, your own rationality in terms of how you address people can be a very useful tool in a variety of circumstances, particularly starting with the pandemic and the entertainment industry.
Say, can we give Hillary a Vivicoff an answer to her question? A client comes back from a vacation to a place where a quarantine is recommended. Do you have to pay them for the quarantine period while they can't come to work?
If it's recommended,
yeah, they flew to England. It was okay when they flew to England. There was a hot spot in London, exactly where they were. And now they're coming back to the United States, and there are regulations that say you got to stop for 14 days before you can go out in the world, and you have to be on Ellis Island.
My wise guy answer is if you sent them there, you certainly have to pay.
Yeah, that was my thinking too.
If you didn't send them there, I think
the
it becomes negotiable, like most things in the entertainment industry.
But I didn't see that. If they sent them there, if they were sent there by the employer, and I would be surprised if they wouldn't have an obligation to pay. I agree.
But Hillary says, but they went there on vacation. So
right, okay.
So
Well, do they have to? Well, we know that the employer can ask certain questions about the employer. Whether they have to be paid for the quarantine if it was a personal vacation, I'm not so certain, frankly. I'm not sure. For example, assuming the executive order is renewed, I don't think the workers' comp presumption would apply because they were on a personal vacation. They weren't anywhere near the workplace. They didn't have anything to do with the workplace, as far as I know.
Like much of life, there's a status issue here. We know that the union is going to think of this, of course, because they want to protect their interests. So that there will be something in the next union contract which will help nobody now. And then we also know that the major talent, whoever that is, which we can include directors, doesn't matter, we know they're too important, so you'll pay them what you have to keep them functioning, so they'll be the adult human being you need them on stage to be.
Well, that's the practical reality. But
yeah, well, that's where I come from.
Well, and I think you're right. However, keep in mind the question that I discussed earlier about an employer's right to defer the start date for a job offer for a new hire, and that's permissible. And I don't think the new hire gets paid during the time that he or she has to delay coming to work. And I think that same principle, or the same concept, would apply here. It's basically the same idea. And I would, as a practical matter, it might be prudent to pay the employer, or at least work out some sort of arrangement, but I'm not sure there's an obligation to do so. I don't think it would necessarily be deemed, the person would be deemed to be suffering from some sort of disability, which might change the equation. But that would be the short response. Max, quick concluding remark, we're almost out of time.
Yeah. I was just saying, even if you put it in the employee manual, because people can have no symptoms and be a carrier of the disease, what kind of responsible employer says, I'm not going to pay you, come to work because you have no symptoms, and then other people become ill? So I'm not sure the employer, if you don't have something in the contract, like if you're quarantined, you get half pay or whatever it is, if you don't address the issue in the contract, which is an attorney's responsibility with their client, I think the reasonable care requirements on an employer to bring someone back when they were innocently on a legitimate vacation, welcome to be there, and it became a hotspot, and tell them, I'm not going to pay you when you come back, you're going to be quarantined now. I'm feeling like that's not an employer who's engaging in reasonable care towards the other employees in their workplace.
I agree, but I'm not certain that the employer would necessarily have an obligation to pay the employee.
Right, that's right. I just think it's something that needs to be put in an employee manual and addressed directly.
Exactly, and of course we can talk about the future, but this is now, here and now. Any concluding thoughts, Max?
Thank you for having such a wonderful panel.
Well,
I learned a lot by reading the things that each of you wrote, so I
likewise
appreciate it.
My only concluding thought is derived from a mediation concept, which is when you're thinking about remedies, think outside the box, put everything on the table, not just the obvious. And I think that's the approach you have to take in dealing with these pandemic-related issues. you really have to be creative in your thinking. And as Max just suggested, and has suggested throughout his presentation, really, and also Jeff, you really have to think creatively and imaginatively. These are unique circumstances, unique remedies, and solutions and answers are appropriate. We want to thank you all for attending. We hope this has been a use to you. And with that, we'll say goodbye and have a good, healthy afternoon.
Thank you.